Chapter 6. Other offenses or irregularities by public officers. Section 1. Disobedience, refusal of assistance, and maltreatment of prisoners. Article 231. Open disobedience. Elements. 1. Offender is a judicial or executive officer. 2. There is a judgment, decision or order of a superior authority. 3. Such judgment, decision, or order was made within the jurisdiction of the superior authority and issued with all the legal formalities. 4. Without legal justification, offender openly refuses to execute said judgment, decision, or order which he is duty-bound to obey. Act constituting the crime. Open disobedience is committed by any judicial or executive officer who shall openly refuse to execute the judgment, decision or order of any superior authority. Article 232. Disobedience to order of superior officer, when said order was suspended by inferior officer. Elements. 1. Offender is a public officer. 2. Order was issued by his superior for execution. 3. He has for any reason suspended the execution of such order. 4. His superior disapproves the suspension of the execution of the order. 5. Offender disobeys his superior despite the disapproval of the suspension. Note: refusal to do so constitutes contempt, for by his resistance and refusal to do so, he undertakes to dictate to his superior. Note: provision does not apply if the order of the superior is illegal. Article 233. Refusal of assistance. Elements. 1. Offender is a public officer. 2. A competent authority demands from the offender that he lend his cooperation towards the administration of justice or other public service. 3. Offender fails to do so maliciously. Note: there must be damage to the public interest or to a third party, great or small. Article 234. Refusal to discharge elective office. Elements. 1. Offender is elected by popular election to a public office. 2. He refuses to be sworn in or to discharge the duties of said office. 3. There is no legal motive for such refusal to be sworn in or to discharge the duties of said office is justified. Note: if elected person is underage, or otherwise disqualified, his refusal to be sworn in or to discharge duties of the office is justified. Note: once an individual is elected to an office by the will of the people, the discharge of the duties of said office becomes a matter of duty, not only a right. Note: Article 234 is not applicable to appointive officer. Article 235. Maltreatment of prisoners. Elements. 1. Offender is a public officer or employee. 2. He has under his charge a prisoner or detention prisoner. 3. He maltreats such prisoner in either of the following manners. 1. Overdoing himself in the correction or handling of a prisoner or detention prisoner under his charge by either A. Imposition of punishments not authorized by the regulations, B. Inflicting such punishments, those authorized, in a cruel and humiliating manner, or 2. Maltreating such prisoner to extort a confession or to obtain some information from the prisoner. Note: public officer must have actual charge of the prisoner to hold him liable for maltreatment of prisoner. Note: offended party must be a convict or detention prisoner. Note: to be a detention prisoner, the person arrested must be placed in jail even for a short while. Note: maltreatment must 1. relate to the correction or handling of the prisoner, or 2. must be for the purpose of extorting a confession or of obtaining some information from the prisoner. Note: if jailer inflicted physical injuries on the prisoner because of a personal grudge, he is liable for physical injuries only. Note: Offender may also be liable for physical injuries or damage caused. Note: there is no complex crime of maltreatment of prisoners with serious or less serious physical injuries, as defined in Article 48. Note: Republic Act No. 9745 Anti-Torture Act of 2009 prohibits the use of torture and other cruel, inhuman and degrading treatment for punishment. Section 2. Anticipation, prolongation, and abandonment of duties and powers of public use. Article 236. Anticipation of duties of a public office. Elements. 1. Offender is entitled to hold a public office or employment, either by election or appointment. 2. The law requires that he should be first sworn in and/or should first give a bond. 3. He assumes the performance of the duties and powers of such office. 4. He has not taken his oath of office and/or given the bond required by law. Article 237. Prolonging performance of duties and powers. Elements. 1. Offender is holding a public office. 2. The period provided by law, regulations or special provisions for holding such office has already expired. 3. He continues to exercise the duties and powers of such office. Note: a public officer who has been suspended, separated, declared overaged, or dismissed cannot continue to perform the duties of his office. Article 238. Abandonment of office or position. Elements. 1. Offender is a public officer. 2. He formally resigns from his position. 3. His resignation has not yet been accepted. 4. He abandons his office to the detriment of the public office service. Note: there must be a written or a formal resignation. Note: if the abandonment of the office has for its purpose to evade the discharge of the duties of preventing, prosecuting or punishing any of the crimes falling within Title I and Chapter 1 Title 3 of Book 2 of this Code, the penalty is higher. Note: abandonment of office or position is committed by any public officer, while negligence and tolerance in the prosecution of offenses is committed only by public officers who have the duty to institute prosecution for the punishment of violations of the law. Note: in abandonment of office or position, the public officer abandons his office to evade the discharge of his duty, while in negligence and tolerance in the prosecution of offenses, the public officer does not abandon his office but he fails to prosecute an offense by dereliction of duty or by malicious tolerance of the commission of offenses. Section 3. Usurpation of powers and unlawful appointments. Article 239. Usurpation of legislative powers. Elements. 1. Offender is an executive or judicial officer. 2. He makes general rules or regulations beyond the scope of his authority, or b. attempts to repeal a law, or c. suspends execution thereof. Article 240. Usurpation of executive functions. Elements. 1. Offender is a judge. 2. He assumes a power pertaining to the executive authorities, or b. obstructs the executive authorities in the lawful exercise of their powers. Note: legislative officers are not liable for usurpation of powers. Article 241. Usurpation of judicial functions. Elements. 1. Offender is an officer of the executive branch of the government. 2. He assumes judicial powers, or b. obstructs the execution of any order or decision rendered by any judge within his jurisdiction. Note: Mayor is guilty under this article if he investigates a case while justice of peace is in the municipality. Note: Articles 239 to 241 punish interference by officers of one of the three departments of the government with functions of officers of another department. Purpose is to maintain the separation and independence of the three departments of the government. Article 242. Disobeying request for disqualification. Elements. 1. Offender is a public officer. 2. A proceeding is pending before such public officer. 3. There is a question brought before the proper authority regarding his jurisdiction, which is not yet decided for. He has been lawfully required to refrain from continuing the proceeding. 5. He continues the proceeding. Article 243. Orders or requests by executive officers to judicial authority. Elements. 1. Offender is an executive officer. 2. He addresses any order or suggestion to any judicial authority. 3. The order or suggestion relates to any case or business coming within the exclusive jurisdiction of the courts of justice. Note: purpose of the provision is to maintain the independence of the judiciary. Note: legislative or judicial officers are not liable under Article 243. Article 244. Unlawful appointments. Elements. 1. Offender is a public officer. 2. He nominates or appoints a person to a public office. 3. Such person lacks the legal qualifications, therefore 4. Offender knows that his nominee or appointee lacks the qualifications at the time he made the nomination or appointment. Note: offense is committed by nominating or by appointing. Recommending, knowing that the recommendee has no qualification, is not a crime. Note: appointments of non-eligibles continue only for such period not exceeding 3 months as may be necessary to make an appointment through certification of eligible, and in no case shall extend beyond 30 days from receipt by the Chief Executive of the Bureau or Office of the Commissioner's certification of eligibles. Note: legal disqualification in Article 244 of the RPC simply means disqualification under the law. Section 4. Abuses against chastity. Ways of committing abuses against chastity. 1. Soliciting or making immoral or indecent advances to a woman interested in matters pending before the offending officer for decision, or with respect to which he is required to submit a report or consult with a superior officer. 2. Soliciting or making immoral or indecent advances to a woman under the offender's custody. 3. Soliciting or making immoral or indecent advances to the wife, daughter, sister, or relative within the same degree by affinity of any person in the custody of the offending warden or officer. Elements of the offense. 1. Offender is a public officer. 2. He solicits or makes immoral or indecent advances to a woman. 3. Such woman must be a. interested in matters pending before the offender for decision, b. under the custody of the offender who is a warden or other public officer directly charged with the care and custody of prisoners or persons under arrest, or c. the wife, daughter, sister, or relative within the same degree by affinity of the person in the custody of the offender. Note: mother of the person in custody of the offender is not included. Note: solicit means to propose earnestly and persistently something unchaste and immoral to a woman. Note: crime of abuse against chastity is consummated by mere proposal. Note: not necessary that the woman solicited should have yielded to the solicitation of the offender. Note: proof of solicitation is not necessary when there is sexual intercourse.